in terms of the imbalance in power, we recognize, I would say, employment relations by its very nature, there is a tension because the interest may be different in that I want to push my economic interest, I want to make profit. As an employee, I want to participate in this economic development. I want to be rewarded accordingly. The effort that I put in must be reflected by the reward that I'm getting back. So therefore, that tension will always exist, and that tension needs to be dealt with.
But when you talk about fairness between two parties, where one has more power and has more decision-making power, that fairness, the idea of fairness between them, becomes fairness from the position or from the perspective of the powerful, of the more powerful. I don't want us to go down the rabbit hole on this, but this is my thinking around it. Now, you did mention, to sort of address this, you did say, look, the employee has the right to join a union or a workplace, I don't remember the word. Forum, a workplace forum, for them to represent themselves more equitably, internally, before involving anyone else. So I do think that partially addresses that. But in the absence of a union or a workplace forum, would you say that the employee is still at a disadvantage within that internal process?
Not necessarily, it will depend. Remember, the principle of fairness rests on two legs. The process that was followed or the procedure, and the reason for that procedure. That is the test for fairness. Sometimes the procedure was fair, but the reasons were unfair. Sometimes the reasons were fair, but the procedure was not followed to the T. Then those are the things that we are going to determine when the matter is brought before us.
Would you say that it would be beneficial to social justice, the cause of social justice, let's say in general, for the procedure, the principle of fairness to be able to be tested at the internal stage?
Hence, when an employer formulate allegations against you, they call you into a hearing, a formal hearing. Remember, they can also conduct an informal hearing.
Okay.
They appoint an independent chairperson. Now, independent chairperson, whether you are a director or a manager, in that capacity, you will be independent from the employer, independent from the employee. You are going to take off your cap as an employee of the company. You must act independently, exercise your sense of fairness, deal with that, control that process in that way. And remember, if you are appointed as a chairperson, you are not suddenly a judge or a magistrate. And that hearing room does not turn into a court of law where you want to prove cases beyond reasonable doubt. You exercise your sense of fairness independently from the employer, because the employer has now delegated you with powers to make a decision or powers to recommend. Now, when two parties are sitting across the table against each other, you are sitting there, you listen to those things, and in the end you will weigh and make a decision.
To make sure that I understand correctly, the internal hearing, which you said can be informal or formal, right? An independent chairperson is appointed by the employer, right? And this independent chairperson is an employee of the employer, but once they take that position, they take off their cap. And they are protected in terms of from any backlash based on their conduct or how they handle. So, for example, are they protected from the employer for how they handle that hearing? For in terms of backlash, I'm using the word backlash, but I forgot what the word is now.
Remember,
victimization.
If the employer appoints you in terms of their discretion, and they say, "To me, we appoint you," it means they trust that you will make an independent decision. And they will stand by that. or if you are empowered to make a final decision, or if it's a recommendation, they can agree, or they can come with a different sanction than the one we have determined. So you, by virtue of you being independent, that means you apply your mind, you exercise your sense of fairness without any fear of.
Just a question: why is it it's the employer that appoints the chair? Like, does the employee have a role in that?
You see, it brings it back to that power relations.
Decision making.
Yeah, and power relations. Again, to say, because it's an internal matter, the employer is the one who has that prerogative.
You know, my thinking around this is that internal. When we say handle this internally, this is an internal matter.
Yeah.
For me, I would prefer to think of it as internal to the relationship rather than internal to the business. Right? So my understanding would be that there's a dispute in the relationship between the employer and the employer. And the internal hearing is to be held, or they need to decide together, because it's the relationship that they have together. And it seems to me, like you said, there is a power differential, that it's only the employer who decides. And I would say, do you see the mismatch that I see in terms of this is the relationship between you and me, but you're the one that decides whether or not we get a marriage counselor.
Okay, that's why you bring a neutral person in the form of a chairperson.
Okay, you did mention that. You said that the employer can bring an outside person, like, for example, you use the CCMA as an example.
As an example.
Does the employee have a voice in that decision, in saying, look, let's bring someone from the outside, in terms of that decision?
Well, they can agree in a contract of employment without necessarily labeling the person to say, let's go to an independent dispute resolution institution, or let's go to non-arbitrators, let's appoint an advocate or whoever, somebody familiar with employment relationship, because at the end of the day, it doesn't matter who you appoint.
Yeah.
The test is the fairness. That is the test. And this relationship, remember, is not just it's a business relationship. And whose business it is the employer's business. Does the employer have the right to write, roughshod over people? No. That's where the law comes in. That's where other forums steps in to neutralize the power. That's where unions also step in, because there's power in numbers. If they act as a collective, they may be able to withstand the might of the employer, or even force the employer to concede.
How is labor law promulgated? And just to qualify that, would you say it's through public participation processes, so on, that the government facilitates, and then from there it has its own process after doing that to promulgate the laws?
Yeah, remember you've got your network where social partners debate these things.
Social partners?
Yeah, social partners. I'm talking about labor, business, government, society, and the community may also be invited to make a contribution and input. From there, it will go down to, the process of parliament, debated, go back and forth. And in the end, once the president promulgated upon the signature, then it becomes our law. But remember, the laws can be amended from time to time, adjusted here and there
side of labor, what would you say, how would you assess the employees outside of labor unions, right? So a non-unionized employee, how would you assess their ability to participate in these processes?
Look, the law does not discriminate whether you belong to a union or not, but if you belong to a union, there are added advantages because they can be able to fight for your rights whilst you continue, and they have that muscle to act as a collective. However, the stats are very clear that a majority of employees do not belong to unions. And there are also other things that also cripples the unions, economic factors. You get retrenchment, you get companies going down, and that impact on the powers of union in terms of the finances, being able to be everywhere all the time. Right now, some employees are very sophisticated in that they can access information online, then they can be able to express themselves. Although some employees still, because of ignorance or fear, they only get to hear about the union when the union is on strike. And they associate unions with strikes, etc., which is not true, because unions does a lot of behind the scenes. They represent employees internally and externally. They also fight for the improvement of the benefits of the employee. So they do a lot of work. Maybe unions need to sell themselves better.
I would